Well, good evening. It's nice to have you all here for our estate planning session tonight. And it's my honor to introduce Mr. Tim Williams, who I've had the opportunity to work with for the last, well, I think almost 12 years. He's been part of PC2 longer than I have, and he's been part of our community in terms of he's a board, was a board member for PC2 for a long time. He'll introduce himself, but I want you to know that we have appreciated the expertise that he brings to us and the wonderful help that he's given to so many families here in Pierce County as an attorney who has prioritized this area of law with his practice. And he's been able to really help a number of families with questions. And then if they choose to be able to work with him for any kind of specific help, he's been willing to do actual legal work for families. But he's here tonight in the capacity as a person to inform us. I want you to know that he comes from a background as an educator. And after he was an educator for a number of years and worked with students in school, he decided to go back to law school and become a lawyer. And then has, as I said, has spent years now in the field in terms of family and particularly law in relation to those individuals who experience developmental disabilities with estate planning and guardianship. And so welcome, Mr. Williams, and please introduce yourself and let people know who you are this evening. But we want everyone to just know how much we appreciate you and respect you as a member of our community. So welcome, Tim.
Thank you very much. Well, as Beth Ann mentioned, I've been doing this quite a long time. I was a special ed teacher for 23 years. I've been an attorney now for over 25 years. I'm a parent, although I do not have a disabled child. I am an attorney. I teach. I still do these things. My biases is for individual dignity and individual autonomy, and recognizing that every one of us is unique. This is the first of 3 seminars that we do periodically, once or twice a year. This one is on estate planning. Next Wednesday will be on special needs trusts and ABLE accounts. And then the following week will be on guardianships, and you're welcome to join any of them. I do encourage you to raise your hand or put something into the chat room if you wish if you have a question right away. There are materials that are going to be available to you, and I think Jonna is going to send those materials out to everybody who is on the email list. The materials include just some general information about estate planning and follows the track of the slides fairly well. But there is also, you're going to get everything that's on the slides will also be coming to you in a separate PDF document. So having said that, let's move on. This is my disclaimer. I am an attorney. I try to keep everything up to date. I believe everything here is accurate, but it's not a substitute for you hiring your own attorney or consulting with your own attorney for individual information. And I cannot give specific legal advice during what we're doing here. So let's get started. Next slide. What is basic estate planning? A good place to start is that all estate planning in the United States is state specific. Every state has a little bit different laws about how you deal with powers of attorney, how you deal with healthcare directives, how you deal with wills and trusts. So this is all for the state of Washington. The basics of estate planning are pretty similar across all the states. So in every state that you go or have been, the basics are power of attorney, a healthcare directive, sometimes called a living will, In Washington, a community property agreement, and we'll talk some about community property and community property agreements. A will, every state has a law about wills, and a variety of trusts. We're going to talk about a grandparents trust, some special needs trusts, living trusts, and credit shelter trusts. Oh, next slide. Power of attorney. I put this first because I think it's the most important document that each one of you should have, and each one of you should have a power of attorney. I have a power of attorney. I had a power of attorney before I became an attorney. What is a power of attorney? It's very powerful. It gives someone else the power to do almost everything you can do for yourself in any sort of legal business sense. When you do this, you needed to designate somebody who you are going to trust. I got to figure out what my next slide is. Excuse me for just a second here. I think oops, I got the wrong one up. PowerPoint. I'm getting a little bit off track. All right, there we go. I'm back. You typically do not give somebody the power to change a will or change beneficiary designations. It is always supplemental. You are designating an agent when you select somebody to be your power of attorney. You are not delegating authority. So when somebody takes the position of a power of attorney, they're acting as your agent. You never lose your own power to make decisions just because you've signed a power of attorney. Powers of attorney are often misunderstood in that sense. And sometimes people are resistant to getting a power of attorney because they think they're giving up some of their own power to make decisions. That is never the case with a power of attorney. You always retain your own decision-making authority in that process. Power of attorney can take effect immediately or upon disability, and it usually avoids the need for a guardianship. Next slide. When you act as a power of attorney, let's see, it's not as necessary between husband and wife because already a husband and wife can do things for each other. Usually your bank accounts are joint and you can make medical decisions for each other, but it makes it much cleaner. And often people have their own separate accounts and you need a power of attorney in order to access those things. It's most important if you are disabled and your spouse is unavailable. I see many powers of attorney for people who only name their spouse as a power of attorney. And it's really important that you have a backup. I typically suggest at least 2 backups for your power of attorney. The gives you power to handle financial matters, power to give informed consent for medical care. Some of the words that we use, the principal, just like a principal in a school, is the person granting the powers of attorney. So if you sign a power of attorney, that means that you're the principal and your attorney, in fact, is the person who is going to act as a fiduciary. In common language, we often say, I have power of attorney for somebody, or I am acting as a power of attorney. The real technical term for that is attorney in fact. An attorney, in fact, somebody who is acting under a power of attorney, is a fiduciary. A fiduciary is a legal term that means that you have an obligation to act in the best interests of the other party. So let me take a few minutes and talk about fiduciary. Next slide. A fiduciary may not act in any manner that's adverse or contrary to the interests of the principal, nor may they act for their own benefit in relation to anything. For example, if you're acting as power of attorney for somebody, or somebody is acting for you, you can't use that person's money for your benefit. You have to use it for their benefit, and there are prohibitions against self-dealing. In addition, you must exercise all the skill, care, and diligence that you have. And if you have special skills, you are obligated to use those special skills. A fiduciary is required to make truthful and complete disclosures to the principal, keep good records, act at the direction of the principal, act as the principal would act, not as you think they should act. Again, these are things that are often misunderstood by people who are acting as an attorney, in fact. Sometimes people get into the role of attorney, in fact, for a parent or a sibling or even a spouse, and they begin to think that they are now just the decision maker. That is never the case in a fiduciary. You are an agent, and you now have an obligation to think about and do what that person would do. Okay, next slide. And actually, why don't you back up a minute and see, does anybody have any questions about power of attorney? Anybody want to raise their hand or put something in the chat room? No. Okay, good. All right. The next document that we typically see when we're doing estate planning is a healthcare directive. Again, a creature of state law. It's also called a living will, provides for death with dignity. The statute for it is RCW 70.122. And it's a fairly limited document. It's only given effect if you are in a terminal condition or in a permanent unconscious condition, never going to wake up. The basic law allows for refusal of CPR or other emergency things, and the withdrawal of food and water, so that if you're in a permanent unconscious condition, then we can remove artificial food and water and allow you just to die with dignity. There have been many, many cases over the years in the popular press where somebody has hung on for many, many years in a coma, still living, getting artificial food and water, because nobody had any right to take that away from them. They had never made any statement to the effect that they didn't want to live that way. I have added many other kinds of things to my healthcare directive. Among them, specific statements about pain management. People typically want enough pain medication to be comfortable, even if that might hasten their death. And specific allowing for the withdrawal or refusal of other kinds of life extending care, the most common of which would be respiratory therapy or antibiotics. Next slide. See where we are. A healthcare directive is different than a POLST, physician order for life-sustaining treatment. Some of you may be familiar with a POLST. POLST is usually on bright colored paper. and is what you might post on a refrigerator someplace if you were at home, or if you're living in an assisted living place, might be readily available so that people know that you don't want to be resuscitated. You're at the end of your life. It's important to note that a healthcare directive does not add any additional power to a power of attorney. It's an enabling document in the sense that it often helps the person who's acting as attorney, in fact, who is acting as an agent for somebody who can't speak for themselves, to make those end-of-life decisions, which are always difficult to make. But it truly doesn't add any power to it. The power of attorney is the document that allows you to actually make that decision. Okay. Anybody have any questions about a healthcare directive? No. Seeing nothing. Moving on. So, estate. Now we're going to talk about what people often think about in estate planning. They don't often think about the power of attorney in the healthcare directive, but we're going to deal with your stuff now. What is an estate? Everything you own. It includes real property. Real property, for those of you that are not familiar with the terminology, means land and buildings on that land. It's known as real property. That's why we have real estate agents who deal with houses. Personal property, those are other kinds of things that you have, like cars and other stuff you have at home. Retirement accounts, IRAs, 401ks, life insurance. I have people think that a life insurance isn't part of your estate. Yes, it is a part of your estate. Everything you have. A right of appointment may in fact be part of your estate. What is a right of appointment? Sometimes people give you, your parents or some other relative might give you the right to make a decision in their will. When they die, they say, I give you the right to send this money off to children or to charities or something, and you can do the same sort of thing in a will or trust. Next slide. So there are a limited number of ways that we can get rid of our estate. The old saying, you can't take it with you. Somehow or another, it's going to stay here when we're gone. So we have gift. We can give it away. We can contract it away. We can have it transferred by title. We can have it go intestate. We can go by will, or we can go by trust. And really, those are about it. Next slide. So let's talk about gifts. Next slide. You can give away any of your things during your lifetime. And that's a good way to get rid of some of your stuff. You can give up to $16,000 per year. This year, next year it's going up. It's for both husband and wife. You can make an unlimited number of gifts. Many of you may have known that you can't give away more than used to be $10,000 a year. It's gone up fairly slowly now to the $16,000 a year, or you will pay tax on it. And that's not true, and we will talk about the taxes. But you can make an unlimited number of gifts. You can gift to anyone. You need to be careful about the tax implications of your gifts. You can make gifts to other people, family members or others, for medical or educational expenses. There are no taxes to the receiver. So you can give an unlimited amount of money away if you have an unlimited amount of money, and you won't pay taxes on that, gift taxes, until you've given over $12,060,000. I have very few clients who will ever gift that amount of money. So that's gifting, and we take a look at value, but obviously you don't have to give just money. You can gift anything. Next slide. So this is an old cartoon from Baby Blues. Wow, did you know that we can give the kids up to $17,000 a year tax-free? Really? Yeah, I'll keep that in mind the next time I'm digging for change under the couch cushions to pay for the babysitter. It is something we can aspire to. So I have a question now, so let's take a look at the question. From Marilise. Gift money deductible before tax. Thanks, the next slide answered. Okay, we're good. You don't, often people come to me and it's one thing they know is that I can't give more than that amount. And that is just not true. Or that if I give more than that amount, somebody will have to pay tax on it. Neither of those things are true. Again, the tax is not due until you've given over $12 million. It's a common misperception. It does trigger the obligation to file a gift tax return. No taxes due, but if you give more than $16,000 this year to any one person, then you, as the giver, have an obligation to file a gift tax return. It's a fairly simple return. You don't need to hire somebody to do it. But it's important that you know that you have that ability. All right. So we're not going to give it away yet. Let's see how we can contract things away. Next slide. Life insurance, retirement accounts, employee benefit accounts, business agreements are all contractual arrangements. You have a contract with the life insurance company that says, I purchased life insurance company from you. If I die, we have a contract. And under that contract, you have to pay my beneficiary, whoever I've designated, a certain amount of money. Same thing for an IRA or 401k or other kinds of employee benefits. Business agreements, if I have a business with somebody else, we have a contract between us that says certain things have to happen when I die. So that's a contract. The community property agreement is also a contract between a husband and a wife. It can only be between a husband and a wife. And we're going to talk a little bit more about community property agreements in a minute. All right, next slide. So there are 9 community property states: Louisiana, Texas, New Mexico, Arizona, California, Nevada. We skip over Oregon, Washington, Idaho, and Wisconsin. All of us except Wisconsin come by way of community property through the old land grant Mexican laws. We were all at one point part of Mexico. There are common misunderstandings about community property, but it does not convert all property indent to joint at the time of marriage. Lots of people think that. Next slide. So community property is a presumption that everything you acquire during a marriage is community, belongs equally to both the husband and the wife. There are some exceptions. If you brought property or debts into a marriage, those are not community property. Those remain your separate property. Sometimes people get married and one of them or both of them already have a house. That house is separate property because they owned it at the time they got married. Property gets its character as either community or separate property at the time it's acquired. Inheritance and gifts, personal injury settlements are also not community property. They are your separate property. If you change title on things that have your name on them, you may affect the character, so that if you get that inheritance and put it into a joint bank account, that may turn it into community property, but not necessarily. It gets it's not automatic, and it can get kind of confusing. Commingling, putting your money into a joint account again, may make it the same. Or if you take a house that you owned when you came into the marriage and you put your spouse's name on the title, you may change it into community property. More than anything else, it's important to know that these are presumptions, and that what you decide as a married couple is what decides whether or not it's community. If you decide that everything is going to be community, that's great. If you decide everything's going to be separate, that's also fine. There are some implications to those kinds of decisions that you make that are beyond the scope of what I'm going to talk about here, but they are still available. Next slide. Washington, remember I said there were 9 community property states. Washington is the only one that has a community property agreement. And in fact, it's only good for Washington property, with some minor exception for Idaho property. It is primarily a probate avoidance device, and we are going to talk about probate for those of you that aren't real familiar with probate. But that's the reason people typically get into a community property agreement. The idea is that if you are married, you don't want to have to go through probate for the first of you to die, if you can avoid that. And so a community property agreement is used for that. It is only possible for married couples and registered domestic partners. You can't use it for your siblings or your kids. It converts separate property to community property. Depending on how it's written, it can do that immediately at the time you sign it, or only at your death. And it may also include future acquired property. The only real reason you need a community property agreement for most people is to convert it to community property at death and then transfer it to a spouse without having to go through probate. And our laws in Washington specifically allow for that. So it is found in the law, community property agreement. Next slide. The advantage is that it's easy, it's inexpensive, and it avoids probate. Next slide. There are some problems with some pre-printed forms. It can create problems for higher taxes for larger estates, so that if you have a taxable estate, one that's subject to estate taxes, you probably don't want a community property agreement because you may lose your deduction. If you're on Medicaid, you don't want a community property agreement because the person on Medicaid may become disqualified if they receive an inheritance through a community property agreement. It is also a bilateral agreement, a contract between a husband and a wife. As such, unlike all the other estate planning documents we've done, power of attorney, healthcare directive, will, even a trust, it cannot be revoked without the agreement of both parties. You may want to revoke it, but you cannot. It may not be appropriate if there are children from prior marriages. If you've got a blended family, you want to be very careful about what you do with your overall estate planning. Okay, next slide. Anybody have any questions about community property agreements? Or about community property in general? Okay. title. So we can title things in such a way as to transfer them. Next slide. There's an in trust for designation on financial accounts. So I can hold money in trust for somebody else. You have to be careful about in trust for documents because you need to be very clear about whose money it is today. You can title things in the name of a trust. Trusts are very common throughout the United States. You can have pay on death designations so that I have a financial account that will pay to somebody else on my death, or a transfer on death. Okay, little bit different, but very similar to a pay on death designation. It transfers things, it avoids probate. Don't need to worry about probate. I have already designated. It is a contract in the titling process so that I will have this with a bank or an investment company or in a deed. I can have a transfer on death deed that I record, and that will transfer property and avoid probate because I've titled it that way. I can also own property as joint tenancy. And there are two general types of joint tenancy. Next slide. Oh, we're talking, okay. Transfer on death deed. We have 29 states with a transfer of death deed. It may be appropriate for some states. It's very useful for out-of-state property, so that if you have property in another state for which probate is much more difficult, you can use a transfer on death deed to do that. Next slide. So joint tenancy. If you own something with somebody else, you are now a joint tenant with that person. Doesn't have to be two people, it can be three, essentially an unlimited number of people. Each of the tenants owns the entire property, so that if I own a vacation cabin with my two siblings, we each own the entire property. We have a right to be in the entire property. We don't separate it out for this is my third and this is my sister's third and this is my brother's third. We each own the entire property. It's most appropriate for couples, but I have seen many joint tenancy of a variety of things. And it doesn't have to be real property. It can be vehicles, it can be investment accounts, it can be checking accounts. Having joint tenancy with other people may create problems for you. So you want to be very careful about owning anything with anybody else. It's most appropriate for a married couple because you really do own the property together, especially in a community property state. If you own this property with a sibling or a child or a parent, you can lose estate tax credits. You can lose a step up in basis when you die. If you assign children as joint tenants, again, whether it's real property or bank accounts, you can create ambiguities and problems for dealing with that particular property. And you have a potential for loss of control. Remember, if you have a bank account with somebody that's not your, especially that's not your spouse, you're giving them control over the whole property. And if they take all of it, you can create problems for yourself that way. Next slide. So I said there are two types of tenants, of joint tenancy. One is called tenants in common. And if you don't specify what kind of joint tenant you are, this is the default under the law. Each tenant can gift, sell, or will their interest in the property. So if I own that vacation cabin, 1/3 each with my two siblings, I can gift it, sell it, or will it away to somebody else. I'm not obligated to give it to the other joint tenant. Each tenant's of interest is available to creditors, so that if my brother goes bankrupt, they can come and force us to sell so that the bankruptcy judge can get and distribute the money that's available there. There may be some gift tax implications to giving property to somebody to make a joint tenancy. And it doesn't avoid probate. And you may lose the step-up basis for the part transferred. I get a lot of people who come and ask me and suggest to me that they would really like to retitle their house in the name of them and their child or their children. They think it's going to be easier to transfer that way. And it is not. It actually complicates things a lot. It's not generally a good idea. You have some tax implications, and you're, excuse me, and you're not going to avoid probate. Next slide. All right. Joint tenancy with right of survivorship. This is a specific kind of joint tenancy. And in order to be a joint tenancy, right of survivorship, you really need to use those words. And remember I said that all of this is state specific. Some states use a little bit different wording on it. So you need to be careful about what you do if you have property in other states. When you own something with somebody else as joint tenancy with right of survivorship, it does avoid probate and the survivor takes at death. If I own a house with my spouse and I title it as joint tenancy with right of survivorship, it will pass automatically to my spouse without probate. But it can skew an estate plan, and you may lose some estate tax credits, and the asset may be available to creditors. Again, between a husband and wife, it's a great thing to do. With others, not so much. So you want to be very careful about how you title things. If you have a joint banking account with somebody, especially with a non-spouse, it is generally treated as a joint tenancy with a right of survivorship. So if it's all your money that's in there and you have a joint account with a child, then when you die, that child is going to get all of that money. It's not necessarily going to go to your other children or to other places that you expected it to go to. All right. Any questions about joint tenancy? No. Okay. Next slide. So there are specific hazards about assigning children as joint tenants. If they are joint tenants, again, whether it's a bank account or real property or an automobile or anything else, if they become divorced, their business fails, they have liability claims, they die prematurely, you may have some issues with getting that property back to you because you have essentially given them part of the property. You may lose a step up in basis. Now, I've used that term step up in basis a number of times here. Let me make sure everybody understands what that means. If I'll use a house as an example. If I have a house that I bought for $200,000 and I live in it for 10 years, and then I sell it for $500,000, I've made money on that house. I've made $300,000 on the house. Now, there's an exemption for a house that I've lived in, but if it's a rental or if I'm doing something other than a house, I'm going to have to pay taxes on that. And the capital gains tax ranges from 5 to 20%. If I give part of my house to a child or to somebody else, and then I die, they've already got an interest in it. So they do not get the step up in basis that they would otherwise get upon my death. In a community property state, community property gets a complete step up in basis. In non-community property states, when somebody dies, only half the property, only the property that belongs to the person who died, gets a step up in basis. So there are some significant tax advantages to not naming other people as joint tenants. Next slide. Okay. I can do none of these things, and my stuff can pass intestate, which is a big legal term for passing outside a will. Now, I see that there's a question out
Right.
there about basis.
Right.
What is a step up in basis? Again, let me go back and use an example of a investment account. Let's say that I purchased $100,000 of Microsoft stock, and I hold on to it for a couple of years, and I sell it. And I sell it for $200,000. I will have to pay long-term capital gains on that increase, and I will have to pay for it in the year that I sell it. There's okay, in the chat, I'm looking at this. I am paying on my house estate. If I pass away, I would like my daughter to have my house. If there is stepchildren involved because of this second marriage, can the stepkids step in and cause issues for my daughter? That's a little bit different issue. It is one thing that you want to have a will for. Let's talk about, and I will come back to that particular chat question here in a minute. If you die intestate, then the state has already determined where your stuff is going to go. If you're married, all of your community property will go to your spouse. But if you have some separate property, only 1/2 of your separate property goes to your spouse, and 1/2 of it will go to your children. That may be what you want, but that can really complicate things. And I've dealt with issues where people thought that because we were a community property state and they got married and they owned a house when they came into the marriage, so it was their separate property, they were under the misperception that that was all community property and would go to their spouse. And it did not. It was separate property, so only half went to the spouse. The other half went to the children. You have to be very careful about what you do with your property. If you have no children, then 1/4 of it goes to your parents, if your parents are still living. If you die intestate, next slide, I think we've got some specifics about this. Then it will go to your brothers and sisters. If you have minor children, a court is going to appoint a guardian ad litem for those children to make sure that the money is well protected. It's going to increase the cost of your probate and take a lot of the simpleness of what probate is out of it. It's much more difficult Yeah, I'm not going to say that either. It is more difficult, not much more difficult, to probate if you haven't done a will. And of course, everybody's family situation is different. So it really depends on what your particular family situation is. Next slide. And this will be in your materials. This is a little more extensive about exactly what happens if you die intestate. Next slide. So the most common way to distribute your stuff when you die is through a will. So let's talk about a will. You can specify the distribution. So in the chat, if you've got a will, you can distribute the house to who you want it to go to. If you have minor children, you can nominate a guardian. If you have a disabled child, you do not nominate the guardian through your will because that person is an adult. That is done through the court process. But if you have minor children, you get to do that. You nominate the executor. We call the executor typically a personal representative. And you can say who's going to manage your estate. You can create trusts. And the most typical kinds of trusts, and we're going to be talking about those trusts, are special needs trusts or grandchildren's trusts. You can also give to charity. It's never going to get to charity if you don't put it in your will. If you die intestate, no way to get to charity. And I encourage my clients to think about the charities that they give to now and think about charities in your will. Next slide. A few words about probate, because lots of people think that if I have a will, I get to avoid probate, and that is not the case. Probate is a creature of state law, and it is very different in many states and from state to state. In Washington, it is simple and usually inexpensive. It can be both complex and expensive in other states. I typically probate for a flat fee of $2,800 plus costs, and costs generally run $500 to $700. That's $3,500, and that's not nothing, but it's not very much. Many states have very complex probate laws. California, Arizona being a couple of them, and it can cost tens of thousands of dollars to probate in those states. And we're going to talk a little bit more about that. Property is not tied up. It's fast and easy. I have opened and closed a probate in less than a week. It passes the property pursuant to the will or testate. A personal representative in Washington may be paid, but it's not a fixed percentage. In some states, they have the executor of the will gets a certain percentage of the estate. Depending on the size of the estate, the percentage changes. Not true in Washington. And quite frankly, for most families, you have a family member, typically one of the either spouse or one of the children doing the probate. They're doing that for their siblings, and they don't charge. Next slide. It's required in Washington if the probate estate has any real property, that's land or buildings, or more than $100,000 in assets. Now, there are some probate avoidance devices even in Washington. Smaller estates, if you don't have any real property, you must wait 40 days, and it's done by an affidavit, which is just a way of saying I have to declare that I have a right to this money. In some states, they allow some small amounts of real property to pass outside probate, and at least one state has no exception. Every estate must be probated. Next slide. Why don't we make wills? You get too busy, or too little property, or you think it's too expensive. You don't like legal documents, unable to know the future, don't plan to die. That's my plan, actually. We'll see how that works out for me. Next one. So let's talk about trust. Next slide. What, in fact, is a trust? A trust is a creature of English law. It comes to us from our history of being initially a part of England. And we find in many parts of the world, they don't really know about trust, don't understand trust. But in our state, our country, a trust is a separate legal entity. To be effective, assets must be titled in the name of the trust. Unlike a person, a trust doesn't die. It's not a breathing person, so it doesn't die. And so it doesn't die, we don't need to do probate. There may be tax implications for things in a trust. There is nothing that can be done in a trust that can't also be done in a will. A trust can be standalone. I can set up a trust today, or I can put a trust in my will for the future that springs into life at the time that I die. It can be revocable or irrevocable. Next slide. Every trust has three elements: a grantor or settler, somebody who sets up and funds the trust; a trustee, somebody who manages the trust; and a beneficiary or beneficiaries, somebody who benefits from the trust. Some trusts, you can be all three. I can set up a trust for myself. I'm the grantor, I'm the one who puts the money in. I'm the trustee, I'm the one who manages it, and I'm the beneficiary. I'm the one who benefits from the trust. Next slide. So there are a number of kinds of trusts that we see typically in estate planning. A grandparents trust is a trust that I would typically put in the will in order to leave things to my grandchildren. Now, I will tell you, most of my clients want to leave their stuff directly to their children. They have no real desire to put their grandchildren into their will. Some do, but most don't. But we still put a grandparents trust into the will because for most of my clients, if one of their children should predecease them, they want that deceased child's share to go to their children. And so we put that trust for those grandchildren. It's a contingent trust. It says if my child dies, their share goes to their children. The grandparents trust, then you get to select the age at which those grandchildren get to take their inheritance, and you get to select who the trustee is going to be. Often it's an aunt or an uncle, but it doesn't have to be. It can be a professional or some other family member or a bank out there if it is a large enough amount. And what's really important in this is that you get to select the age at which those children actually get to take their estate. If you're doing your will with minor children, you would have this kind of trust for your own children. But for most of my clients, we call it a grandparents trust because it's skipping over a generation, going down to the grandchildren. 18-year-olds don't inherit well. It's both my personal and professional experience that nobody should receive a significant inheritance at age 18. Most of my clients think that you have to be 25 or 30 before you're really ready to accept a significant inheritance. And so those are the ages they select. A special needs trust is a different kind of trust. Again, that's something that can go in a will or be standalone, but for most of my clients who have special needs children. They put a special needs trust into their will. This trust then becomes irrevocable upon their death, and they get to leave an asset to their special needs child. Is specifically authorized by both state and federal law to not affect any needs-based benefits that that special needs child would have. So that if you have a child who is on SSI or Social Security disability, getting Medicaid services, in-home care, any number of things, you can leave them money that can be used and must be used for their benefit and not have it affect their other benefits. And so it's a really important thing to do. I have parents who come to me routinely and saying, I don't think I need that. I'm going to leave everything to their siblings and they will take care of the special needs child. In many cases, that will work. Maybe even in most cases, that will work. But the problem with this is it doesn't work in every case because you can't predict whether those siblings are going to be there. They might predecease, or whether they're going to be in good financial shape. If you leave it to them, it's their money. And if they get divorced or go through a bankruptcy or have some other problem in which the money just goes away, then it's not going to be needed. It's not going to be there for your special needs child. So I always recommend that you decide you want to leave something to your special needs child. Do that in a trust. Do that so that it's protected there and can't be used for anything else. And we're going to be talking next week a lot more about special needs trusts and about ABLE accounts. A revocable living trust is a specific kind of trust that is the most common way that people avoid probate in other states. If you listen to Susie Orman or other nationally known financial pundits, they will tell you, you should have, you must have a revocable living trust because you must avoid probate. That is a true statement in many states. It is not true in Washington. A revocable living trust, remember I talked about being the grantor, the trustee, and the beneficiary. In a revocable living trust, I am all three. And that's typically the reason. Vast majority of revocable living trusts are set up just for that reason, to avoid probate. So I put my stuff into a trust. And then when I die, I don't need to worry about the probate. I can avoid the probate costs, and I can just have my successor trustee distribute the property as I have designated in my trust. If there are problems between beneficiaries of the trust, a trust is sometimes more difficult to take to court, and sometimes it can be unfair in that sense. There is nothing that I can do in a revocable living trust that I can't also do in a will. And there are companies out there who will try to sell you a revocable living trust, and they will say, you need to have this, and they will have a very fancy book, and they will charge you a lot of money, and you need to be very careful about those. There's something else I need to tell you about a revocable living trust, but it escapes my mind at the moment. An exemption trust for estate tax avoidance is another trust that we put into a will. If you've got enough money that you may be subject to an estate tax, and Washington has an estate tax threshold of $2.2 million. So if you've got $3 or $4 million, you may want to put an exemption trust in your will. And the purpose behind that is to make sure that for a married couple, both of them get the full $2.2 million exemption. I won't go any further into it than that, other than to say that you really need to talk to an attorney if you do have a significant assets. There are lots of other kinds of specialty trusts, gun trusts, pet trusts, a variety of things that you can put in your will or standalone. Next slide. The grandparents' trust, again, is the most common. It's usually in the will. You get to select the trustees. You select the age of distribution. You avoid the cost of a guardian ad litem. It can be simple or complex. Next slide. Special needs trust. It's most common in a will, but it can be a standalone. One of the things that when my clients come to me and they say, I need a special needs trust, my question for them is, where's the money going to come from? And if the money is typically going to come from them, this potential client or already client, when they die, then it's easiest to set up in a will. There are a variety of reasons why that makes it less complex and in fact less expensive. If on the other hand, they're going to get the money from someplace else, an inheritance that is not going directly into a trust or something else, we can set up that special needs trust for them now. Again, we'll be going into this much more extensively next week. Next slide. A few brief things on managing a special needs trust. And again, we'll go into much more of it next week, but if you are in the position of needing to manage a special needs trust, you have to keep good records. Usually means you don't use cash. Keep all the funds separate. Use the money only for the benefit of the beneficiary. Don't give money or things that are easily converted to money, such as a cash card, to the beneficiary, usually. And there are some exceptions to that. Sounds an awful lot like being a fiduciary, which we talked about at the beginning of this. And that's exactly what you are. When you're the trustee of a special needs trust, you are a fiduciary. We can talk all day about what it means to be a fiduciary. Next slide. Revocable living trust, primarily a probate avoidance device. There are no tax implications. There are no special reporting to IRS, no tax ID requirements. You must title your assets in the name of the trust, and you must be sure that non-titled assets remain below the probate limit. I deal with a lot of people who move up here from California. California has very difficult probate, and so many of these clients come up with a revocable living trust. They've got it, they know it, it works. The problem is that they come up here, they sold a house typically at a good price in California, come up here and buy a house, and then they just put the house in their name. They have a perfectly good trust, but if the house is not in the trust, it's not going to work. The house is in your name. We can solve that problem if you're comfortable with the trust by retitling the house into the trust. Or if that's the only thing we need to worry about, sometimes we just defund the trust at that point and leave the house where it is. And that's often a less expensive proposition. Next slide. It can be very good for out-of-state property, and it's very standard practice in many states. You don't need it to avoid probate or to protect privacy. There are some other things that we can do here that we've talked about. It is almost always more expensive than a will. There are alternatives in case of incapacity. You still need a pour-over will. And I've given you a link to some revocable living trust information from the Washington State Bar Association. Next slide. A word about taxes. Okay. Income taxes. when people come to me and their parent has died or their spouse has died, they're really worried about taxes. Death is generally a non-taxable event. Income taxes, when you make money, you're going to pay taxes on it. If you put that money into a retirement account like an IRA or a 401k, you get to not pay tax on it when you put it in, but you're going to pay taxes on it when it comes out. If you put a beneficiary designation on it, then the beneficiary, when they get the money, is going to need to pay taxes on it. And that is typically the only tax that most people going through a probate will have to pay. The money that was in a retirement account that had not previously been taxed is going to get taxed. So what other kinds of taxes do we pay? We talked a little bit about the capital gains tax. It's the tax on the increase in value. And again, if I use my Microsoft example, I have 100 shares of Microsoft that I paid $100,000 for. And if I sell it at $200,000, I'm going to pay capital gains tax. The 100,000 is my basis. What I sell it for is its fair market value on the day of sale. If I die with that $100,000 or that $200,000 worth of Microsoft stock, there is no capital gains, because under the present tax law, if any property that I have when I die, and in fact, any community property when either spouse dies, gets what's known as a step up in basis. Next slide. Oh, let's go back one. I thought I had another slide on step up in basis. So you may have heard that term, and what that means is that I no longer have to pay tax. So my children, if they inherit from me, whether it be a house or a bank account or stocks, if that asset has appreciated, gotten larger in value, they don't have to pay a capital gains tax on it. That's a big benefit, because if I gifted it to them, again, if I gifted the house to my child, they get my basis in it. My basis is what I paid for it. So if it's a $500,000 house and I pay $200,000 for it, if they get it by inheritance, they get a $500,000 house, and that's their basis. If I gift it to them, they get a $200,000 house, and when they sell it for $500,000, they're going to have to pay taxes on it, on the difference. So there's, and again, everybody's situation is different, but you need to be careful and need to be aware of those taxes. Next slide. This is where I talked about the federal gift tax exemption. For 2022, it's $12,060,000. There's an unlimited marital deduction and an unlimited charitable deduction. So we can all aspire to this. I can assure you I'm not anywhere close to that amount, and I suspect most of you aren't either. It's a unified gift and estate tax. So again, there's no gift tax until you've given all that amount. The 2023 figure is $12,800,000. It's going up by inflation. Next slide. Washington State has an estate tax also, although they do not have a gift tax. So we don't need to tell the state if we gift money away. It is not indexed to inflation. It's for 2.193. I said 2.2, pretty close to 2.2. 2.193 million. There was a period of time in the in the 2010 to about 2018, where most people didn't need to worry about this. But with the increase in inflation and in the increase in the value of homes, more and more of my clients are finding that they, in fact, do have significantly more than $2 million. And so you need to be careful that there's an estate tax out there. And there are some things that we can do to make sure for a married couple that you each get your 2.193 exemption. Next slide. So when should you review your estate plan? Family change, birth, you're getting older, somebody dies, significant asset changes. If you all of a sudden have a whole lot of money or all of a sudden have quite a bit less money, I recommend that you review your estate plan every 2 to 5 years. Make sure that the tax law hasn't changed. Make sure that it has a self-proving affidavit. Next slide. Also, when you review it, you also want to make sure you know where it is. In this internet age, there are lots of resources online. Wills, trusts, powers of attorney, healthcare directives, they're all available online. Why do you need an attorney for all of that? Why should I do that? You go to an attorney for advice, for an explanation, for understanding, and the knowledge that your documents will really do what you want them to. I've seen internet wills that were okay. I've also seen internet wills that were disastrous. Next slide. So a good attorney will ask you the kind of questions you didn't think to ask yourself. Everybody's family is unique. If you're doing anything other than a standard, everything to your spouse and the kids, the grandkids, we can walk you through all the possibilities. Next slide. So getting a will is quick and easy. You want a power of attorney, maybe a healthcare directive, but you also want to make sure that you get it done. All right, that's it. Do I have any? I don't see anything else in the chat. Is there anybody else who has any questions? Anybody who wants to unmute themselves and actually talk to me?
Right now, since we don't see any questions right there, but we can stay on and we can end the recording, and then people could stay on and ask their personal questions they might be more comfortable asking that would not be recorded. We'll be happy to do that. Before we do that, I'd like to remind you that Jonna will be sending out the copies of the information tonight that you saw. So you'll have that copy for you. And then along with that, we just have a quick little survey. If you'd please take a couple minutes and fill that out, we would appreciate it. We have a contract with the county. And one of the things we're supposed to do is make sure that we're asking you questions about whether or not what we're providing for you is helpful and meaningful. So please take a few minutes to give us a little bit of feedback. And with that, I'd like to thank everyone for coming tonight to learn about this important information. And I'd like to thank Tim for taking time to go through this. I know we've been an hour and about 20 minutes, which is a great deal of information. So we want to thank you, Tim, for being organized and clear. And thanks so much for doing that. And so we'll end the recording right now. And then we'll be able to stay on so that we can ask questions, and you can unmute yourself and just be free.